You're at, ma'am,
What?
this is not going to help.
It don't matter. My life's on.
Well, looks like you did that, not me. I'll see you in 3 weeks. Which, come on, hold on, get her, don't let her go. Come back.
I said what?
I heard bullshit.
Everybody heard it.
You said you're bullshit.
Come back. You don't talk like that to anybody in this case because he didn't do this either. You did.
He got me the
He did get you he did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. Still Bogan, this is sentencing. Good morning. This is Mr. Hoffpower sentencing. I didn't see you over there, Mr. Hoffpower. Good morning. Good morning. Are you Crystal Bogan? And Ms. Bogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes.
And any additions or corrections or speak up? I'm sorry.
I just want to make sure.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's... I mean, she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if anything? I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, ma'am.
school with this type of criminal history? Where do you live now? Okay. Another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct? Well, it says $500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the car.
Okay. So possibly the other person that was involved did that?
But if it was a withdrawal, then that would be her responsibility joint and separately. So
Right. It says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, $94 from inside the bank, $500 from an ATM, and $100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the, yeah. So I mean, if there was another person and you didn't give that information, then that's, okay. Apparently the cops didn't either, so, and hold on. So the probation's in Sutton County. Have they been transferred to Harris County? So you're going in person in Harris County? Okay. And so it's the state's position to go forward with the agreement?
I understand the court's concern. The state has the same. Like I said, our initial deal was to get some of the money back on our victim. However, we understand.
So, all right. So here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. It has to be straight probation. And I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing. So you do. Okay. How many do you think you have?
I have 3 hearings and one back here.
Okay, you have lots of them that were at the same time for different offenses. Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail. So that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation. So that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit. And that's the 10-year probation that you're on in 5 different cases.
Okay.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all. It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. Let's see. Can you? All right. I'm going to set your bond at $25,000. Go back with the bailiff. Let's see how today goes. I need the certification. Please. If I'm gonna, we'll see. I mean, my main thing is a convict, and we're done with the first for her. So, see what y'all want. All right, ma'am, you're Crystal Bogan. And Ms. Bogan, when you were here yesterday for sentencing in cause number 25 DCCR 0026, just so the record's clear, I rejected that agreement based on your criminal history. The fact that it was a deferred probation, I feel like with your criminal history, it is at this point, if you're going to accept responsibility, time for a conviction. You were going to be able to leave yesterday. There was an incident in the courtroom. Based on all of that, I raised your bond. Mr. Lewis asked that we bring you out today. Mr. Lewis, what is...
Well, yesterday afternoon, I went and spoke with Ms. Bogan about everything going on with the case. One, she did apologize to me, and she said, of course, when she had the opportunity, she wanted to apologize to you, the court, for her actions yesterday. I did explain to her as far as where we were as the case, the rejection was there on the deferred. You did kind of put us at that point, you would have to be a straight probation with the restitution if she was to be on any type of probation. She told me she was more than willing to accept that. She understands how it may affect her with her job, but she wanted to still, if that opportunity was there, she wanted to definitely take it.
Mr. Hoffpower?
Judge, in light of all that the court's already mentioned and cited. We're going to leave it to the court, but we would not be inclined to put her on probation after the way she acted and due to her criminal history. So we would, if the court wants to allow her to do straight, that's fine. I understand.
Yeah, well, that's what your argument was yesterday.
It was.
To continue, for me to go forward. So, I mean, the most important thing to me, obviously, I don't know that you deserve a probation at all with your criminal history. But as I said yesterday and today, it is time for you to have some responsibility and some consequences for continuing to commit felony offenses. You know, it's great that you can finish a deferred probation, but at some point you got to quit getting felony offenses and quit violating the law. And so I don't think that's fair at all. So what I can do, I have the paperwork still from yesterday. And if you guys would want to agree to a convicted probation, I can make that modification on this punishment recommendation. And then I can kind of reinstate everything up to the plea and all of that. So we don't have to go through all of that. So I'll reinstate everything we've done prior to today, make that modification on the paperwork, and go forward with sentencing. Is that everyone's agreement?
That's fine.
That's fine with us.
The modification will be a 2/5. It will be a 5-year probation. It will be a convicted 2/5. I am going to, I'm not inclined to order a fine because I want that restitution paid. So I'm going to mark through that. So with everyone's permission, I'll make that change. And that's what everyone's agreement is. Is that correct? And I want to make sure you understand that this is now your agreement. And so if I follow an agreement to give you 2 years in the state jail, but probate it for 5 years, order that restitution, you can't change your mind later. This is your agreement. Is that correct? Okay. All right. Then what I'm going to do, let's see, restitution. And the restitution will be that $10,000. And that's everyone's agreement as well, correct?
Yes, correct.
All right. Then at this time, Ms. Vogan, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your new agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $10,000 fine, restitution, and to follow all of the rules and conditions of probation. If you do this is still a good opportunity because you will be able to serve that 2-year sentence while you're out on probation instead of in the state jail prison. The other side of that, though, is if you violate any condition of probation at all, you will be brought back into court and you will be facing that 2-year sentence that I just gave you. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, ma'am. Do you need my PSI? I printed it out. Okay, you've got everything. I'm sorry, I just printed my PSI. Y'all can throw that away.
Orders, but I have them.
You have them? Okay.
Judge, if it's okay with the court as well, be able to apologize.
Yes, ma'am. I appreciate that. Make sure that while you're on probation, that you don't let those emotions also get in the way of you being cordial and doing what you're supposed to on this probation, as well as the other one that you're on, because that just in itself could get you right back in here. Even if you disagree with whatever they're ordering, if you disagree, you disagree. But you have to do everything they said. You have to be cordial. Thank you for your apology. You can go back with the bailiff.
Thank you.
Is that the way the case should be evaluated for punishment at this point when somebody's failed on probation? Or should she receive some sort of additional sanction on top of what that punishment will be because she's failed at probation? Are people punished in addition on the sentencing because they failed at probation? Does that entail an additional punishment? And I would suggest to the court that it shouldn't in her case. She hasn't received any new offenses. She's paid the restitution. So in looking back at what an appropriate sentence would be on the revocation, one should look at the case as it was, and the circumstances as it was when she received the deferred, and the court should ask itself, well, what would be the appropriate punishment if she hadn't taken deferred at that point? And I think in looking at that, the court would hopefully would agree that at 1244, I would say 1244B, where she doesn't have the felony convictions, but certainly a 1244A is appropriate. That actually convicts her of the state jail offenses, but would give her the county jail time of 180 days, 180 days state jail, or 180 days county with the state jail conviction, although I would hope that the court would consider 1244B, where she would just receive the misdemeanor convictions. That would be in line with what the facts of the case were at the time that she received the deferred. Now, obviously, she hasn't done much on probation other than pay the restitution, but should she receive some sort of additional sanction or punishment for failing at probation, separate and apart from the underlying offense? And I would argue to the court that in this circumstance, that would be inappropriate, that a 1244 would be the proper way to proceed.
Mr. Coleman?
Thank you, Your Honor. I'll be brief. This is one of those rare instances where Mr. Kimler and I agree. She has failed abysmally at probation, Your Honor. Those were his words, and I join him in that sentiment. Judge, she's only paid the restitution now that an MTRP is hanging over her head. She's essentially done nothing since she was placed on probation. She goes on to probation in June of 2024, and she's not reporting the very next month or two after that. She's done nothing in the way of satisfying the conditions of her probation. Conditions, Judge, that are not recommendations by the court or suggestions by the court. It's your order. You ordered her to do these things, and she just disregarded the court's order. Even more than that, it is a waste of time, a waste of resources that could have been devoted to another defendant or defendant's judge. And based on that, I'm asking the court to revoke the defendant's probation and sentence her to no less than 12 months in the state jail.
And I would just respond, Your Honor, briefly, is would 12 months have been appropriate when she originally pled?
Well, I don't know that I agree that, and I think it's a case by case situation, but where we give someone an opportunity, where I give someone an opportunity and resources that someone else could have taken advantage of, I don't know that I agree that it should go back to what it originally was. You had an opportunity, and there should probably be punishment for what you did and possibly something for what you didn't do when you were given an opportunity to not have 2 felony convictions on your record. I can tell you now, 1244 of either type is out of the question. So here's where I am. Ms. Capel, you've stated, you've agreed that you have a substance abuse issue. They tried to get you some help through JCDI. Your option today, I'm going to give you an option. 2 things. If you want to not have a conviction on your record, a felony conviction, you want to try to be successful and do better and get the tools to do better, then I'm willing to do that. But it's not going to be getting out today. It's going to be inpatient treatment through the ISF program, which is the 90-day program. Then you get out, and then you're go through JCDI as aftercare, so that you can hopefully live the rest of your life without being here and looking at go to prison. If you don't want to do that, then I'll sentence you to somewhere in state jail prison time. But it's not going to be 1244. You're not going to get to sit in county jail and do your time for not doing anything you were supposed to while you're on probation.
Would the court be inclined to indicate what the length of state jail would be to evaluate the court?
It would be somewhere in the range of what Mr. Coleman is asking for. I don't think that is an inappropriate ask.
What do you want to do? Yeah, she's checking her back. I think she has around 2 months right now.
The thing is, and I'm not going to try to talk you into doing something, because if you don't want to take advantage of what I'm offering you, that's fine. But here's the thing. If you want to just do your time, I get it. It's probably easier to do your time and get out. But you're going to be a convicted felon 2 times over. 2 felony convictions on your record. You're not going to be able to get certain jobs. You're not going to be able to live in certain places and apartments. You're not going to be able to vote. It's going to change your life. If you think your life is negative now because you're on probation, it becomes 10 times worse with the actual convictions. If you want to take your chance and do that, then you can. But if you get out and you continue to use, you continue to do things like steal and forge checks because you're using to try to get money to use, you're going to still be in the same place and you're going to be back in here. Then you're going to be looking at felonies that are enhanced because you already have felony convictions. So that's my spiel. I'm trying to give you an option here today that is probably not what you want in the short term, but is a whole lot better in the long term. So, do you want me to hold it for a minute? Y'all can go visit?
Yes, Your Honor.
All right, go talk about it. Let me know what you want to do. Can beg somebody to. Mr. Gertz on Chad Holland. I see. Got it. 24 DCCR 1616.
No, I hear you. Please, no messenger shooting today.
I don't ever blame you for advocating for your client.
Maybe I should charge some extra for trial. Maybe that was.
Run your shop the way you want to run your shop, Mr. Gertz.
That wasn't very nice. I guess it was nice.
Good morning, sir. You're Chad Michael Holland. And Mr. Holland, in cause number 24, DCCR 1616, you're charged with the third-degree felony offense of fraudulently securing documents by I'm saying the wrong, deception, but it says executed documents. Anyway. And that offense is from December 30th of 2023. Your indictment alleges that you were previously convicted of burglary of a habitation March 15th of 2004. And after that was final, you were convicted of fraudulent use of identifying information October 7th of 2020, and also possession of a controlled substance, a second-degree felony, October 7th of 2020. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is a minimum 25 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here that shows that the district... What's going on over there? Everybody needs to, if y'all are going to be here, you need to sit up straight in your seats. We can get you a comfy seat up here if you want to come be closer to the action. But if you're going to be here, you don't sleep in court. That's disrespectful, okay? So sit up, get your hand off your head. Everybody sit up. Eyes open, pay attention, please. So, I have a plea bargain rejection that you've signed with Mr. Gertz that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty, and that would be plea into counts 1 and 2 only, for a 15-year term in the institutional division of the Texas Department of Corrections. Do you understand what your possible consequences are if you go to trial and what your options are? And do you want to reject that offer and have your case set for trial? Yes, sir.
I'm sorry to interrupt you. I'd like to point out that that 15-year offer was a one-time today on the offer. I communicated that to Mr. Gertz that I would waive one of the enhancement paragraphs or a couple of the enhancement paragraphs to get us to that 15 to 99 punishment range. But,
Okay.
I have every intention of proceeding on the habitual offender if we go to trial.
And y'all talked about that. And so, Mr. Holland, I want to make sure you understand that after today, I will not accept this plea agreement. If you change your mind later and want to enter a plea of guilty, it would be to something different than this or to the indictment with the minimum 25, unless there's some new information or evidence that comes to light that either Mr. Gertz or Mr. Coleman don't know about today. Do you understand? And you want to reject that offer and go to trial. Is that correct? All right, we'll get it set on the trial docket. Mr. Gertz will begin preparation. Mr. Kimler on John Mayen, sentencing, 23 DCCR 0461. I'm sorry? Yes, hold on, Mayon, please. Somebody's here. Who's coming in?
We're about to tell them we don't need them because I think we have an agreement.
Okay.
If you follow, it's the recommendation of probation.
On who, what?
Corbin Thomas.
Corbin Thomas, sentencing.
The report suggested ISF, even though we essentially got kicked out of safety. It seems kind of limited though.
Okay.
It's a MTRP for messing up safety.
And he's fine with that?
They want to
Mr.
return-
Kimler?
Yes.
Well, on Thomas, y'all have an agreement? Let's get Corwin Thomas, please, ma'am.
We could, I can just tell them that we reached an agreement. Where are they? Sandy, outside of Corpus Christi. That should be Lieutenant Perez. You're gonna examine him anyway? No, I was gonna let them know. Hi, Lieutenant, can you hear me?
Can you unmute yourself, please?
We're not, it's just.
Okay. Yes, I can hear you.
Hey, Lieutenant, this is Luke Nichols with the Jefferson County DA's office. We've reached an agreement, so we're not going to need your testimony this morning, but I want to thank you for making yourself available.
All right, sir. Thank you.
Have a great day.
Thank
You
you.
too.
All right, sir, you are Corwin Thomas Jr. And Mr. Thomas, you were previously in court and entered pleas of not true to counts 1, 2, and 3 in a motion to revoke your probation. So I'm guessing we need to go back through that motion for change of pleas. Is that correct?
Yes, sure. Yes, sure.
Give me a second. Pull this up. And Mr. Thomas, the best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And will he waive the formal reading again of that motion?
So wait,
So now, how do y'all want me to do it? If I've already revised one and I'm going to do it again, take the original and do it again, or take the revised? So make another copy of the revised. Mm-hmm. All right, so there's a motion to revoke your unadjudicated probation, and cause number 24 DCCR 0542 shows you were placed on probation for aggravated robbery July 29th of 2024, and that was a 10-year deferred probation, correct? And so it alleges that in count 1, you failed to never become intoxicated or under the influence of an intoxicating substance, and that you were on February 10th of 2025. And is that true or not true? True or not true?
true or not?
Listen to my question. True or not true? Thank you. So then count 2 alleges that you're behind in your court-assessed fees. Is that true or not true? And then count 3 alleges that you did not successfully complete the safety program. Is that true or not true? Did you enter your pleas of true freely and voluntarily? And because those 3 counts are actually true. All right, and I've received an updated report before, if y'all both had an opportunity to review that report.
Yes, sure, we have.
And it's my understanding that everyone is of the opinion that even though you didn't successfully complete SafeP, that I give you an opportunity and send you to ISF to see if you can get through that and then hopefully be successful. Is that your understanding? Is that everybody's?
Yes, Your Honor. It's based on the probation officer's recommendation and my understanding and agreement that with his age and the severe consequences facing him if he is revoked, that a chance at ISF to get on better decision making and a chance to actually complete.
And is it Cognitive or substance abuse?
Appears, the recommendation appears to be substance abuse. I don't know. That's,
Is that what you suggest?
Substance abuse and followed by JCDI?
correct.
Okay. You know, I could send you to prison today for the rest of your life. That's how serious this is. If you don't make it through ISF and you come back here without ever getting out because you did whatever was going on in safety, if that all continues, there won't be another chance. And you're going to go to prison before you ever even really get out to get on probation. So I want you to take advantage of this, because I'm going to look back at this and I'm going to probably think, why did I do this? And you don't want me to think that later, because it usually ends up really bad. I want you to be successful and I want you to take advantage of all of these opportunities, but you're going to have to go in there with a different mindset. You're going to have to get past however it was, whatever you were doing out on the streets, however you were living. If you want to live a normal life, have a family, have a job, just live normally without all of this in prison, then it's time for you to come to that decision and take advantage of this. Do you understand? Okay. So I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation and order that you enter and successfully complete the substance abuse track of the ISF program, and that you will then, when you're out, do the outpatient treatment through JCDI. All that's meant to help you make better decisions, get off drugs, do the right thing. If you do that, you still don't have the felony conviction on your record. And so you'll still be able to live your life without saying I'm a convicted felon. But if you violate, like I said, you'll be right back in here. You can be convicted and you could go to prison for anywhere between 5 years and up to the rest of your life in prison. You understand? All right, take advantage of this. Good luck to you.
Thank you, Mark.
Yes, sir.
Let me chisel this for a moment.
Okay. Mr. LeBlanc on Preston Fontanet.
Corwin, it could be a future of you didn't tell me. I told you.
Do what?
With the Corwin comments in the future, it could be a, you get to tell me I told you.
I know, right? Every now and then it happens that way. Every now and then.
But
All right, so this one, he pled to counts 1, I guess,
paragraph 1 contains a.
count 1 previously, so we're just gonna go through that again. All right. All right, will your client waive the formal reading of the indictment?
I'm sorry.
Will he waive the formal reading of the indictment? Mr. Fontanet, in cause number 23, DCCR 20, sorry, something just popped up.
2079.
I just had stuff start coming on my computer. 2079, the state's elected to proceed on count 1 only. It alleges you committed the 3rd-degree felony offense of unlawful possession of a firearm by a felon September 29th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. LeBlanc?
Yes.
Do you fully understand them? And do you understand, if I follow this agreement, that you'll be waiving or giving up any right to appeal? Also, and so the agreement is the same as before. It's a 10-year sentence in prison that would be probated. You'd be on probation for 10 years. Fine, was there a fine?
$1,000 fine.
A $1,000 fine, and you would be required to follow all of the conditions of probation. Is that your understanding? Speak up, please.
Yes, yeah.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
We have no objection, Your Honor.
It's admitted. Is there any evidence that Mr. Fontanet is not competent?
None that I'm aware of.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. We've already gone over the pre-sentence report. Is there any reason not to go forward with sentencing?
Not in light of his renewed plea, Your Honor.
Then at this time, I'm going to find sufficient evidence to find you guilty and find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over and you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, and your probation revoked, and you would be facing that 10-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. LeBlanc. All right? Good luck to you, sir.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Jeremiah Johnson, Mr. Parker. Oh my gosh, I'm gonna need, y'all wanna, did y'all print any of those? Jeremiah Johnson by chance? It's got 4 cases. On Johnson's cases, are we going on the indictments as they are, or are there changes? Okay, I'll get through them. Y'all don't have to print them. I'll figure it out. Yeah, I got it. I'll do it. Nope. If I don't have to change them, I can, I'll get through it.
Judge, I did not write CC on there, but they're all, the deal is to run CC.
Okay. Good morning. Are you Jeremiah Johnson? And Mr. Parker, will your client waive the formal reading of the indictment in each case? Just a second. Mr. Johnson, in cause number 25 DCCR 0330, you're charged with a first-degree felony offense of aggravated robbery from February 27th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25 DCCR 0331, you're also charged with a first-degree felony offensive robbery from February 27th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And again, are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
In cause number 25 DCCR 0408, you're charged with the state jail felony offense of theft of a firearm from February 27th of 2025. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And then finally, in cause number 25 DCCR 0409, you're also charged with the state jail felony offense of theft of a firearm from January 30th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? In all 4 of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, you'll be waiving or giving up any right to appeal?
What I have to do as a kid, so?
Yes.
All right.
And so it looks like the agreements that you've reached with the district attorney's office in the 2 ag robbery cases is for a 10-year deferred probation with $500 fines, and then a 5-year, is it 5?
2 over 5, 2 years probation for 5.
On the state jail.
And then a 2-year term in state jail prison with a conviction, but probated for 5 years on the theft of a firearm case. Is that your understanding of your agreements? So on the 2 aggravated robberies, it would be 10-year deferred probations, which means no convictions on your record on those 2. But if you violate a probation, it gives me the whole range of punishment. On the 2 state jail felony offenses, it would actually be a conviction of the state jail felony with a 2-year term in state jail prison. But that is, the agreement is to probate that, and you'd be on probation for 5 years in those 2 cases. Is that your understanding?
And that brings this courtroom drama to a close. What started as a plea for probation turned into a serious confrontation over criminal history, courtroom conduct, restitution, and accountability. The judge ultimately gave the defendant another opportunity, but this time, with a conviction, 5 years of probation, $10,000 in restitution, and a 2-year sentence waiting if she violates the terms. The biggest lesson here is simple: getting a second chance doesn't mean getting unlimited chances. Once the court gives you an opportunity to stay out of custody, following the rules becomes absolutely critical. Do you think the judge made the right decision by allowing probation, or should the defendant have received jail time instead? Let us know what you think in the comments, and don't forget to like, subscribe, and stay tuned for more courtroom breakdowns.